Today's case is a double DWI bombshell. Meet Carly Davis, or, as the judge clarifies, Carly Hooser, 2 active DWI cases for prior offenses, and a bond hearing that's about to spiral into a tense legal standoff. What starts as a routine bond review quickly unravels into a battle over prescription drugs, public safety, and personal accountability. The judge isn't holding back, questioning the validity of prescriptions, the doctor's credentials, and whether this defendant can even be trusted behind the wheel. Watch closely, because what happens next raises a crucial question. When does a prescribed medication become a public danger? Let's dive in.
All right, you're Carly Davis and Carly Hooser, and this is 24 DCCR 1385 and 25 DCCR 1237. And so we were going to be here on reviewing bond conditions, correct? And then the state has filed a motion to increase the bond.
Yes, Judge.
And is that in both of the cases or just that one?
In both cases, Judge.
Let me pull this up. I know I took a look at it last week, but.
This one's right.
And so we've got both of these cases are driving while intoxicated, third or more. The first offense date is from May 6th of 2023. The second from February 10th of 2025. So I've got some history with regard to prescriptions. Some of it's obviously very hard to read, but it looks like.
This is where things get complicated. The defense insists Carly's failed drug test was caused by her prescribed medications, not illegal substances. But the judge and prosecutor see it differently. Under Texas law, DWI isn't limited to alcohol. It includes any impairment, even from legally prescribed drugs, if they affect your ability to drive safely. The problem? Carly's history shows a pattern of misuse. For prior DWIs, and another arrest while already out on bond. It's a classic courtroom dilemma. Prescription versus responsibility. Should leniency be given because the drugs are legal? Or should the court prioritize community safety over medical dependency? What do you think? Is the judge being too harsh or just protecting the public?
Prescriptions for alprazolam and something called D-amphetamine. Okay. Can't tell the date. One of them specifically says no refills. I can't read the dates on these.
We can get better photos, Judge. She had had that prescription for.
All right, shows it expires October 31st for the.
Judge, I had a number of questions about those photos myself. I mean, I'm not necessarily, well, I guess I am questioning the validity. This doctor that allegedly prescribed it, this Rajan Desai, there's either an Austin address or a Millburn, Texas address for this doctor. When I looked him up through the Texas Medical Board, and I'm just a little curious about.
So where do you go to the doctor? Where's this doctor from?
From Beaumont, and I do a telemed every month except for the last October's office. I don't report it today.
Today?
Yes, ma'am.
Where specifically?
Telemed today.
Oh. Well, here's what I think.
In the end, the judge strikes a firm but measured balance, giving Carly one last chance. She must consult her doctor immediately, switch to non-narcotic alternatives, and provide documentation or risk having her bond raised and being taken. Back into custody, this case underscores a growing issue in modern DUI law: how courts handle prescription-induced impairment. It's a legal gray area where medical need collides with public safety, and the stakes couldn't be higher. What's your take? Should courts show more compassion for prescription dependency or tighten restrictions even further?
What I think I'm going to do, based on the nature of what these medications are and the history. Well, are you driving? Okay, I don't know if I already did, but a condition of your bond is going to be, as of today, that you are not allowed to drive any vehicle ever, period. Okay, so if you're caught driving, obviously you'll be right back in jail without, probably without a bond. Mr. Coleman, other than a no driving, is there any other?
You know, Judge, I just would like to reiterate, and we put it in our motion. It sounds like the court's read the motion, but you know, she's got 4 previous DWIs, Judge, and in addition, she picked up this latest DWI while out on bond for a DWI.
Right.
And that, along with the positive drug test, I think the public safety, the community safety demands some additional assurances.
And Judge, our argument would be that the DWI itself is for the medications. She's been on these medications for.
Well, it doesn't matter if you're on medication and you're
Right.
taking too much medication, then that's a problem.
Sure.
So you can be on these medications and not be.
Also, the failure of the drug test was for these medications.
Right, I understand that. My biggest concern is the fact that if the medications are not being taken properly or too much of the medications, then that's a larger concern with the safety, and I completely understand and agree with Mr. Coleman on that. How'd you get here today? Here's what I want you to do, what I'm going to order you to do. I'm going to order that at your appointment, I'm requiring you to find out and with your doctor, get a prescription for something that is non-narcotic. So something that is not going to cause these issues if in fact our concern is that you are misusing or overusing these medications, then there's other medications that you can take. You need to talk to him today. I want you on your way to be off of both of these medications and on something that would not lead to the issues that you're having. Does that make sense? You need to get that information from him, find out what he can prescribe. I want those to Ms. DeLage, and I want her to get those to me. That is a condition of your bond at this point. If you don't do that today at that appointment and get that information to her, then I'm going to, what I'll do today is not rule on Mr. Coleman's motion. So that motion to raise your bond is still out there. And if you don't get this information and you don't get this done today, then your bond will likely be raised and you'll be in jail. Do you understand? All right.
My only question is, the medication to get off of it abruptly can cause.
I understand that. I'm not saying you have to get off of it abruptly. I'm saying I want the plan and how you're going to do it, what it's going to be reduced to, what it's going to take its place, whatever it is. I want that. You need to tell him that you have been ordered to get off the medications, but obviously that needs to be done in a medical way, but I want whatever that plan is and how you're going to do that, and I want that to Ms. DeLay so she can get it to me tomorrow. Okay? All right, y'all are free to go.
Thank you, Your Honor.
If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns, where legal drama meets real-life consequence.